Afternoon. I hope everyone had a good lunch and a little extended break here. But I hope you're totally pumped to get back in here and talk about super arcane legal issues and litigation when it comes to per and polyfluoral alkyl substances. As Dean mentioned, my name is Rob Lee, and I'm a staff attorney at Midwest Environmental Advocates. We are an environmental nonprofit law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. I've been at MEA in 4 days. It will be 5 years that I've been there. And basically, the whole time that I've been there, I've been working on this PFAS issue. So, and I remember about a year before that, my wife, who previously worked in broadcast news, saying, "Hey, have you heard of this PFAS thing? Right? I think it's going to be a big deal." And I said, "No, it's not. It'll be fine." I couldn't have been more wrong, as all of you know, and it has been a very big deal, and it has been a big portion of my work, whether through the privilege of working with and representing impacted community members, or monitoring and participating in litigation as needed, as Dean was mentioning, or advocacy efforts for needed legislation and regulation. So, very happy to be here. Just a quick overview here. First, we'll just talk about some just legal aspects, not litigation per se or lawsuits or anything but just some of the legal aspects surrounding the regulation of PFAS and really the challenge anytime you're trying to regulate a new type of chemical, right, that we heard Jack earlier this morning describe as emerging contaminants. I want to talk after that about really the most meaningful legal hook that we have for PFAS contamination right now, which is Wisconsin's spills law in Chapter 292 of the Wisconsin statutes. But I will go through and discuss litigation and provide quite a few examples, both litigation that's specific to Wisconsin, but get broader than that, look at some litigation that other states have brought, look at the multi-district litigation over in the South Carolina Federal District Court there. I'll describe a couple of class actions, one of which Beth talked about this morning in the Rob Balot case there. I'll talk about citizen suits under the Resource Conservation and Recovery Act. There have been a couple of those for PFAS contamination. And then very quickly, I'll talk about torts. And I think by the time I get there, it'll make sense why I'm talking about that. So anyway, I just, I want to point out, right, legal aspects in litigation for PFAS is an extremely broad topic, right, and there's no way I'm going to be able to cover it all, so I'm just going to do the best that I can and convey as much information I can in the short time that we have together. So, regulating emerging contaminants. We heard Jack kind of get at this question a little bit, if PFAS even still is an emerging contaminant, and in my opinion, it very much is. But the thing I want to make clear is that it's just a shorthand. It's not a regulatory term. The phrase emerging contaminant is just something we use to refer to chemicals that likely already have emerged in our environment, right? We know that PFAS contamination is rather ubiquitous in our environment. But really what's emerging is our understanding of those contaminants, how toxic they may be, what their fate and transport is, and things like that. That's what is emerging here. These things have been put into the environment for 80 years or more, right? So they're there. That's not what's emerging. It's our understanding, that scientific basis. And we certainly know more about a handful of these chemicals as opposed to the 12,000 chemicals overall. And we're still, every day really, just learning more. Studies are coming out all the time. But we do know enough to know that these things are nasty and they're very scary, especially if they show up in your drinking water supply. The next thing I want to talk about real quick, well, sorry, before I get into that, I think part of the problem with the regulation of the chemical industry in this country is really just fundamentally how it's set up. It is not set up to proactively identify and prevent toxic chemicals like PFAS from getting in the environment in the first place. There is a regulatory mechanism, but there are exemptions to that, like for proprietary information, and there's also a finite amount of time that EPA has to maybe assess a new toxic chemical that a company is proposing to introduce or put into production. And so oftentimes it's not a precautionary approach, right? It's a reactionary approach. And a lot of times we're putting these chemicals out into the environment and only then learning, right, what sort of adverse health impacts come from them. And so that's created a big problem. And I think that approach, right, has basically led to the externalization of the cost of putting those chemicals out into the environment. So there's all sorts of things that we could say are externalized costs, right? The one big one we think about it is health impacts, right? Healthcare costs money. And there is a healthcare burden from being exposed to PFAS that regular people have to pay for through insurance and other things if they're able to do that. Those same people getting sick with different diseases, where you see a lost productivity, right? An economic hit there. We see externalization in costs in not being able to fish and consume that fish, right? Depression in certain industry sectors, economic sectors like hunting and fishing, other types of recreation, right? There's a big externalization of cost. And so I just want to give you a figure. There was a study that came out just last year that was taking a look at the different health endpoints that are associated with exposure to just PFOA and PFOS, right? And looking at just the healthcare costs and lost productivity, not any of those other costs that I was mentioning there. And so for the whole entire country, I think I might have, let me see this. No, this is for the whole country. In 2018, it's estimated, just 2018, that's 1 year, estimated to cost between $5.52 billion and $62.6 billion just for 2018. If we adjust that for Wisconsin's population and inflation to look at what does that cost us in 2023, just for PFOA and PFOS can cost Wisconsinites between $121 million and $1.38 billion just in healthcare costs and lost productivity. Those are pretty big numbers, right, there. And so when we're talking about externalizing costs, though, that means that the manufacturers of these chemicals and those who are responsible for this contamination aren't internalizing those costs, right? Those aren't impacting their bottom lines, and they're able to pad those profits, at least in part there. So that's a big concept that we need to think about. And I'm sweating. The national cost for 2018, that study was $5.52 to $62.6 billion. And interestingly, I don't have this in my notes, but doing a little research, I found an economic study from the Nordic Council of Ministers that was looking at occurrence rates and the same cost over in the European Union, found similar occurrence in the population and very similar to what's happening over here. And if we actually adjust that for exchange rates and population and inflation, it's actually very similar range. So it's interesting to see at least two studies, right, coming out fairly close, recognizing that to some extent, right, these are estimates, right, it can be a little bit indeterminate, but that's a lot of money, right, and just healthcare and that is something that's certainly being paid for, right, by taxpayers and everyday folks right now. The next thing I want to talk about are health advisories versus enforceable standards, and really the road from, right, basically having no regulation and finding out that a contaminant that's put out into the environment may be highly toxic. Okay, well, how do we get from no regulation to, having numerical enforceable standards on the books so that we can get this situation under control. And so two different concepts here. In 2017, right about the time I started at MEA, we had no enforceable numerical standards. I'm stressing numerical standards in Wisconsin for any PFAS here. We did have, in 2016, as you may know, the Environmental Protection Agency put out a health advisory level. It's a lifetime drinking water advisory, right, at 70 parts per trillion for PFOA and PFOS. And basically what that said is if you drink 70 parts per trillion of PFOA or PFOS or more over your lifetime, you can expect to see adverse health impacts, right? That's 2016. So cut to a few years later, I want to say 2019, the Department of Health Services came out with its initial recommendations for PFOA and PFOS, and we heard that earlier from our Clean Water Action Council folks, was at 20 parts per trillion, right? So just in a few years, we can see the science evolving, right? And DHS's numbers going like with that downward trajectory from 70 to 20 parts per trillion. So with those DHS recommendations, the Department of Natural Resources did two things. They proposed a safe drinking water standard under state law at 20 parts per trillion, as well as a groundwater standard set at that same level. And so if you don't really know about how DHS recommendations work, they really are geared for groundwater. They're designed, and that the methodology is set forth in Chapter 160, Wisconsin's groundwater law. But they're effectively drinking water standards. If you look at what's it, 160.13, it sets forth the methodology, and it's talking about like a 20 kilogram toddler consuming that over their lifetime, very similar to what we were talking about for the EPA health advisories. But whether it's DHS recommendations or health advisories, right, those aren't enforceable, just like the fish consumption advisories. They're that, and that's all. So DNR did attempt, after we got those recommendations, to do both groundwater standards and drinking water standards. In addition to that, it also sought to establish surface water quality standards for both PFOA and PFOS, looking at different uses of water bodies and setting thresholds appropriately based on that. So what happened, though, we sort of heard about, at the Natural Resources Board, we went from that 20 parts per trillion recommendation, right, back up to 70, which was EPA, right? We saw the Natural Resources Board do that in February of 2022 with the drinking water standard. And DNR had recommended 20, right, for both of those. But the Natural Resources Board decided instead to go with the 2016, I think what they said was the Obama EPA number. And that is what they promulgated as our state safe drinking water standard right now. With the groundwater standards, unfortunately, the Natural Resources Board ended up in a 3-3 tie. So those standards did not advance, and they didn't. I think they tried to amend it and elevate that too, but the proposed amendment didn't pass. So ultimately, that one there failed. But the point of me kind of telling you that, I'm sorry, I missed the federal safe drinking water standards. We talked about those just a little bit here, but it was interesting. In June of last year, EP actually updated its HALs, right? And they're way lower than the proposed safe drinking water standard. The new HALs they came out with for PFOA and PFOS measured in parts per quadrillion, not parts per trillion. But well below the level of quantification of any sampling test we have or anything like that. Furthermore, the reason we see 4 parts per trillion in the federal Safe Drinking Water Act is because those maximum contaminant levels, right? That's adjusted for what's economically practicable. It's not just a pure public health standard. And so that's why they've settled on 4 parts per trillion for PFOA and PFOS, and then a hazard index level for another 4 contaminants, which is highly complicated and we won't get into today. But the kind of point there, though, is it took from 2016, where we had those EPA howls, right, of 70 parts per trillion, until August 1st of 2022, until that 70 parts per trillion was on the books in Wisconsin as a state safe drinking water standard. So you can see the delay, right, from 2016 until 2022. That's actually pretty good for government work, honestly, but still not even close to as fast enough if you're a person who is sitting there and dealing with this issue on your property. If your private well is contaminated, that's a long time for you. But even then, right, it was just based on the science as we understood it in 2016 and set at a level ignoring the science that developed in the interim. And now we are seeing a federal safe drinking water standard with more updated science in that. But DNR is attempting to re-promulgate those groundwater standards. And despite the updated HALs and the 4 parts per trillion safe drinking water standards, DNR is merely proposing to establish those groundwater standards at 20 parts per trillion and in line with those 2019 DHS recommendations. And so if that's successful and those become valid, say sometime next year, right, even that is a 5 years between the DHS recommendations and getting that standard on the books. So certainly a delay, right, a lag between the science and adopting the standards. And it's a real challenge when it comes to trying to regulate emerging contaminants like PFAS, because you're trying to lock in a standard that people are going to have to comply with, knowing very well that that standard may become stale and outmoded, and even cleaning up to that level could still have public health implications from it. That's not very comfortable from a regulated entity's perspective either, right? That little bit of uncertainty there and how much you're going to have to clean up or how much treatment you're going to have to do. It's a big problem. But the final point I wanted to make here is once we start to establish those standards, right, what do we start to do? We start to force the producers of those contaminants to internalize those costs that they have for decades been pushing off onto society. And when you start messing with the bottom line of, powerful corporations, whether at a state level or a national level, right, there's going to be pushback against that, and there certainly has been here. And when we're developing, especially these rulemakings, I think that is an even more salient consideration because of a provision in the Wisconsin Administrative Procedure Act, so Chapter 227 of the statutes, called the REINS Act. It is the Regulations from the Executive in Need of Scrutiny Act that was passed, well, I can't remember the year, but anyway, within the last decade or so. It's codified in 227, 137 to 139, but basically it states that if any administrative rule would cost either small businesses, local units of government, or individuals more than $10 million in any 2-year period, the agency promulgating that rule must stop. And the only way that they can proceed is by, one, getting a bill introduced in the legislature, passed and signed into law by the governor, allowing them to proceed despite those costs, or 2, to modify the rule to bring those compliance costs down. The big problem with that, though, is those costs are not offset by the benefits of the rule, right? Which may, in certain situations, far outpace, right, the actual costs that are passed on to regulated entities. So it hasn't been a hurdle with the state drinking water standard or the surface water standard, but it very well may be at some point, right, in the future. And it is a legal issue that could be a problem for getting the regulations and standards on the books as a whole here. Okay. So the next thing I want to talk about is Wisconsin spills law enacted in 1978. It's a really, I think, unique and very interesting piece of legislation that DNR has been implementing for over 45 years now. I think they put out a write-up, I want to say in 2018, saying they had had more than 60,000 notifications of hazardous substances spills since the law went on the book, and had remediated more than 30,000 sites throughout the state. You know, and as I'm sure many of you know, right, 1978 is right in the midst of when we were adopting a lot of environmental laws in this country. Only a couple of years later, we saw the spills law's federal counterpart, the Superfund law, or CERCLA, right? And those both have very similar features, right? But like CERCLA, for example, was a direct response, at least in part, to major hazardous contamination issues like Love Canal up in New York and other places. And these laws, they address both the liability and cleanup responsibilities of parties who are associated with that contamination. So, but the laws were put on the books because they recognize that the current regulatory mechanism, which was virtually non-existent, was very ill-equipped, right? Government was very ill-equipped to fund or lead remediation en masse, right? To do that. Our spills law is defined by being responsible party led, right? Not DNR going in and dictating the cleanup. They review the documents that are sent in and the plan for remediation, but it's up to the responsible party and their contractors to get it clean. I think another issue that these laws addressed back in the 70s, right? We're in a very different place than we were almost 50 years ago, is the sort of imbalance of power between some of the polluters, right? These corporations who have a whole lot of resources and ability to hire armies of lawyers versus community members, right? Who are often just individuals living there, and they don't have anywhere close to the resources needed to take on a corporation through direct private litigation of their own. That it was very inefficient and leading to really major community large populations being contaminated with really without any ability to protect themselves, though, and leading to polluters getting away with it, right, and not having to clean up their mess there. I think another issue is, even if you did have the resources to sue that corporation, or maybe even a private individual who caused the contamination, especially with a corporation, they may no longer exist. They may be defunct, or they may no longer be solvent, right? So even if you get a judgment against them, you're not going to be able to defray any costs that were imposed on you. And finally, we can't discount the fact that having large swaths of contaminated property, besides the health impacts, is a very big economic issue, right? That means those properties aren't being really used for anything. They're called brownfields. They're sitting there, often barren, off the tax rolls oftentimes, and depriving communities of revenue and all sorts of things. So a big problem that I think was exemplified by what happened right in Love Canal up in New York, but it's certainly not peculiar to that. This is an issue that's happening all over the country, right here in Wisconsin. So what the spills law did was give DNR the tools to require responsible parties to clean up their messes, to protect public health, and encourage the redevelopment of property to foster economic growth. So I have a couple of definitions up here, and there's no real better way to do it than just give you the language that's in the statute here, and so you can see it. The first one, 292.11.3 there, this is the provision in the statutes that imposes responsibility and what you must do. Now it says a person, And I want you to think about that not only as an individual, but in a corporate personhood sense. You can look up the definition of person and know that it means corporation, individual, LLC, all sorts of things. So, but a person who possesses or controls a hazardous substance, which is discharged, or who causes the discharge of a hazardous substance, what shall they do? Two things. One, they shall take the actions necessary to restore the environment with that qualifier at the end. Do you see that? To the extent practicable, right? It's not you don't have to put it back exactly. It's only to the extent practicable. And the second one here, not eliminate all harmful effects, minimize harmful effects from the discharge to the air, lands, or waters of this state. So you can have a person who either possesses, controls, or who causes the discharge, and they have the responsibility to accomplish two objectives with that. The second statutory provision I have up here, 292.015, this is the definition of hazardous substance here. And I'll talk about this a little bit more in depth when I'm talking about litigation, but certainly the definition of hazardous substance has created a little bit of controversy and how DNR interprets that and implements it. So we can see the definition of here. It's very long, right? And I'll read it all the way through here, but then I'll point out the important parts of it. So hazardous substance means any substance or combination of substance, including any waste of a solid, semi-solid, liquid, or gaseous form, which may cause or significantly contribute to an increase in mortality or an increase in serious, irreversible, or incapacitating reversible illness, or which may pose a substantial present or potential hazard to human health or the environment because of these select characteristics, quantity, concentration, or physical, chemical, or, sorry for the typo, infectious characteristics. And then finally, this term includes, but is not limited to, substances which are toxic, corrosive, flammable, irritants, strong sensitizers, or explosives as determined by the department. So there's the debate over this definition is whether or not DNR has to pass an administrative rule to say that a particular substance is a hazardous substance for the purposes of the spills law. And a case has been brought in order to try to make that so. But what I will say is that in the 45 years that the spills law has been on the books, DNR has never, promulgated a list of hazardous substance or any sort of rule saying that's a hazardous substance. And there's actually requirements in other statutory programs, right, and other regulatory programs, but is conspicuously omitted, right, from this one here. But the other, so that's the approach that DNR's always used, right? They read this definition, or at least my understanding of how they read this definition is any substance. It's any substance, basically in any form, right? Solid, semi-solid, liquid, or gas. So any substance in any form which may cause, right, or pose a potential hazard to the human health or the environment because of things that very well may have to do with the exact circumstances in which a substance is discharged, like the quantity that it's discharged in or the concentration of that substance in an overall discharge, things like that. But that's how I boil that, or that's how it, at least from DNR's perspective, how that's boiled down. It's any substance that poses any threat to the environment or the health or human health. And that it imposes a duty basically on everyone and every business in the state of Wisconsin to know what you're handling and what you put out into the environment. And just because you don't know that it poses a threat is not an exemption, right, from liability here. You have a duty to know what types of substances you're putting out into the environment. And that can seemingly be a little bit oppressive, right? Like, anything, right? What are we talking about here? But I also think we have to apply a little bit of common sense to this, right? It's not as if DNR is going out and prosecuting people because they spilled a beer tailgating for the Green Bay Packers game, or something like that. The example I like to use is milk, right? Not something we think of as a hazardous substance, right? You walk out of the grocery store, you drop a gallon of milk, and it bursts out in the parking lot. Have you discharged a hazardous substance? What do we think? Probably not. Is that going to pose a threat to the environment or the human health, especially because it's on an impermeable surface like a parking lot? Probably not. But say we're in the midst of a global pandemic and milk prices are, falling, and you can't get your, product out, but you have to get rid of it, right? And you say, I don't know, just spitballing here, dump a tanker truck full of milk into a class 1 trout stream, right? It's the same concentration, right, of the substance. Have you discharged a hazardous substance at that point? Very much so. And so, anyway, that's kind of the debate over that definition there, and we'll certainly see how it'll play out in the courts. But I think if the idea that DNR has to promulgate an administrative rule basically contemplating every single scenario in which a discharge of a substance may pose a threat to the environment or public health, they're never going to get there. That's an impossible task, right, to do, especially with some of the hurdles that we have in place. So just keep going here. Just a couple of, I think, interesting points to make. The first, I'll actually go to culpability versus liability first, and I'll come back to joint and several liability. But this is just a means that I use to kind of explain how the spills law works. And certainly it imposes liability on responsible parties. And it may not always be that a responsible party is culpable or necessarily worthy of blame for the contamination being there, right? So just discuss these two cases real quick that have been litigated over the Wisconsin spills law. We see the Mothy case here. It was talking about basically this person had bought a piece of property that already had contamination on it that was seeping from their property to somewhere else, but they weren't a part of the human activity that allowed the contamination to be there anyway. But since they own the property and since it was continuing to seep, the Wisconsin Supreme Court held that this was a discharge and that they possessed that discharge as the owner of the property and therefore were a responsible party under the spills law. So you can see how, at the edges and the margins, there can be a little bit of an oppressive nature of that, where folks are being held liable in some instances, even though they may not be entirely culpable for that spill. Now, the State v. Chrysler Outboard law is very similar to that Mothy case, but I think involved a factual situation where the human activity actually predated the spills law, and there was a claim that it was unconstitutional ex post facto law. And the court said, no, the discharge is happening right now, right? Not before the spills law was enacted. So even if the contamination gets there, right, the discharge can still occur afterwards and usually is an ongoing thing. And particularly when we're talking about PFAS with how mobile they are. And then the joint and several liability thing. You remember when I talked about the fact that those corporations may no longer be around, or maybe they're insolvent? Well, both CERCLA and the spills law impose something called joint and several liability. That means if you are liable for any part of the contamination, you can be held liable for all of it. And the reason for that is basically from, I think, those legislatures' perspective, is that it really should be for the responsible parties to figure out how who owes what money. The objective of the state is to get the property cleaned up, and if you're at any point liable, they may hold you solely liable for that, and let you go seek reimbursement from any other responsible parties may be out there through like an indemnification or contribution action there. So there are mechanisms, but What I've seen in the joint and several liability contexts, especially from DNR, is they, to the extent that they can, are going after culpable parties, right? Because you can think about all the different entities that are involved, right, in the fate and transport of PFAS. We're talking municipal, governments and wastewater treatment plants, and individuals and landfills and industrial facilities and land spreading out on farm fields, and the list just goes on and on and on and on, right? And so that could be a lot of people, right? But we don't really see DNR going after, in many instances, just normal residential people who may not be as culpable, right? So like town of Stella, in a lot of those instances, those landowners may have agreed to allow them, right, to come and discharge or spread that waste on their properties, not knowing, right, that it had those hazardous substances in there. But technically, right, going back to these two cases, if that's still seeping off the property, they possess a discharge, right? But DNR hasn't sent a responsible party letter to them or anything like that, because they sort of get that dynamic between culpability and liability. There's still some rough edges to it, right? But they try to employ, like I said, a little bit of that common sense factor here. The next thing I want to talk about under the spills law before I move on to litigation here is just innocent landowners. And so traditionally under the spills law, there have been two categories of what we consider to be innocent landowners. And one is contamination, right? Not that you allowed to occur on your property, but that was maybe spread on some other property that then migrated onto your property, right? So that's through no fault of your own. That's one category. The other is the property that you bought was contaminated, but you didn't know, and the person selling it to you, either themselves didn't know or failed to disclose that. And it wasn't until 1992 that we enacted a mandatory disclosure law requiring sellers of property or real estate to identify any latent defects in the property that aren't readily observable. Before that, it's just straight up caveat emptor, right? Buyer beware. But really not knowing that was those properties are contaminated. I've seen this particularly be an issue with old dry cleaning facilities where people try to buy these properties and maybe repurpose them into residential units or something like that, where they may be under this category, but have nevertheless seen them get a responsible party letter and have to clean it up, and that can be unfortunate. I will say for the first category, there is already an exemption in the spills law. It's under 292.13, and there are some other qualifiers there, but generally speaking, that first category is already exempt. If contamination seeps onto your property, there's an exemption for you. There has been, over the past, I want to say 3, 4, maybe even 5 sessions, an attempt in the legislature to pass a bill that would create an exemption for that second category. And I think as a general matter, that's a good thing. People in that category probably do need quite a bit of help. But our problem with that is, what are we going to put in its place, right? If we're exempting responsible parties from liability, who's responsible for cleaning that up? Who's paying for it to be cleaned up? What are we putting in its place? And so far, I haven't seen the legislation address that. It's just the exemption. And there have been in the past, particularly again for dry cleanings, like grant programs that instead of exempting them, at least help them pay for and remediate the property. So I just think that's an interesting legal concept that is in the spills law that I wanted to address there. But that's how, at least in my field, we typically think about innocent landowners and how they're divvied up here. Okay, let's get into the big stuff. All right, the litigation here. The first one I've really already described. The spills law case. This is a case brought by a company in Waukesha called Leather Rich Incorporated and Wisconsin Manufacturers and Commerce against the Department of Natural Resources. And they brought 4 claims. One of those claims is related to a subpart of the spills law called the voluntary party liability exemption, which I won't talk about. But the other 3 claims, in essence, 2 of them said that DNR needs to promulgate a rule saying that PFAS are hazardous substances before they can regulate them under the spills law. And of course, DNR disagrees with that. It's been the biggest regulatory hook, really still the most meaningful regulatory hook that we have for PFAS here. But they actually went a little further than that in that case. There's an additional claim in there that actually says, and actually DNR, you have to pass a rule for every substance that you think is hazardous under the spills law, right? Now, in the context of the litigation and following it and reading the briefs, it seems they backed off that one just a little bit, but it's nevertheless a claim in there. And that has serious implications from the spills law, at least as it's been implemented for the last 45 years, would certainly turn it on its head and require DNR to start trying to pass rules, right? To do that, we talked about the barriers, RAINS Act, other things to getting those rules passed, virtually an impossible task. And it really could be tantamount to an implicit repeal of that law, maybe in the most extreme terms. But we'll see where the case ends up. The Waukesha County Circuit Court judge did agree with WMC that DNR needed to promulgate a rule and issued an opinion to that effect. However, that decision was stayed pending an appeal to the Court of Appeals. And the case has been fully briefed and sent up to the Court of Appeals there, and now just simply awaits a decision. This case here may be ultimately destined for our state Supreme Court, but I think the implications of it are very large when it comes to a law that I would hazard a lot of us have probably taken for granted for a long time, right? Because it's been there working in the background and protecting us. Well, it's at risk, and it may not be as much as it has in the past. The second one is another case filed by Wisconsin Manufacturers and Commerce against DNR. This arose out of the promulgation of the surface water rule that I talked about before. DNR wanted to use the requirement to prepare an economic impact analysis and to gather information to do that. They were trying to go out and sample different wastewater facilities, and there was a lawsuit over that. Ultimately, I think the circuit court judge held, or perhaps there was an initial holding in a settlement after that, but the upshot of it was that DNR could sample, but I think they agreed not to disclose the results of that sampling and just use it in the economic impact analysis without like revealing who the sampled entities were. So, but that case just in July was dismissed because the surface water standard was already promulgated and the case was moot at that point. So that's no longer litigation. The next one I have on here is an enforcement action referred from the Department of Natural Resources to the State Department of Justice against Tyco Fire Products up in the Marinette area. And the real issue here stems from 2 things. It's the failure to notify DNR for years of the hazardous substance discharge besides them having known about it. And the second issue really is liability over the broader contamination plume stemming from that area. There is the idea of the contamination from their testing and other facilities, or like right around their facilities. There's also the fact that they put PFAS contaminated wastewater down the drain that went to the Marinette wastewater treatment plant, got in the biosolids like we talked about, and then was spread, and they've certainly resisted liability for that. So we still have a little ways to go before that case gets to trial. I believe it's scheduled for trial in December of next year. So sometimes it takes a little while, but that's certainly a very fact-intensive case and could have very big implications for the folks up in the Marinette and Peshtigo area. The fourth one is not PFAS specific, but it is, oh, Megan, sorry, Megan is getting the text on the screen here, whoever that may be. Okay. This is an innocent landowner case that that WMC, or Wisconsin Manufacturers and Commerce, brought on behalf of a couple, I believe in Jefferson County here, and basically they're trying to overturn that Mothy case that we discussed earlier. That's the upshot of that. This case, interestingly enough, was removed from state court into federal court. I didn't have an opportunity to read all those briefs here, but I was very interested to see that the Department of Justice had sought removal and achieved it to federal court. Okay, and then this is something that was mentioned earlier. I guess I've characterized it as a class action here. I don't know that they've actually certified a class, but this is the lawsuit that you've probably heard about in the news recently that names 3M in addition to a Rhinelander paper mill for the contamination that we're seeing in the town of Stella. And then finally here, I have a potential action against the city of La Crosse because I put potential here because in Wisconsin, for the most part, with limited circumstances, anytime you want to sue a municipality, you have to notify them first and say, hey, we have these claims against you totaling this amount. Would you like to accept that and just go ahead and pay us? Or would you like to deny those claims? And then after 120 days, you're able to then file the lawsuit. So the notice of claims was submitted in June, I believe, for $42.4 million against the city of La Crosse from a PFAS contamination stemming out of their airport there on French Island in the town of Campbell. The city of La Crosse denied those claims, and so it is very likely that soon we will see, if it hasn't been already, that case there being filed. So a lot of Wisconsin specific cases here, I think that have implications not only for the regulatory scheme more broadly, right, but also for particular communities who are facing PFAS contamination. Okay, state actions. All sorts of states, a couple dozen now, I think, have brought some sort of action, some form or another, for PFAS contamination. And these actions have most predominantly been against DuPont or Chemours. They tried to rebrand there, didn't work. But them and then 3M. These are often brought in the state's capacity as a trustee of natural resources. Maybe some of you are familiar with Wisconsin's public trust doctrine, but it's different in different states and may give states different tools there. But basically, these are based on the injuries, right, that these contaminations pose or put off onto natural resources and all the things that come from that. These are also, though, often paired with other types of claims that you can see there: products liability, consumer fraud, and even public nuisance. And these are the different types of damages that have been sought in those cases. Just damages to pay for what happened to their natural resources and the need to remediate or disposal, right? But even the cost to investigate it. Maybe they don't even know the full scope yet, and they need to investigate first to then determine what the damages are. That's certainly an interesting thing. Restitution, I've seen disgorgement of profits, which particularly in products liability and consumer fraud. And then, of course, punitive damages. Yeah, you impose all these costs onto people and they have a right to recover that, but we also want to deter people from engaging in this type of activity in the future. So we oftentimes will see punitive damages. There are really a couple of cases that were filed early on that got all the way through to a settlement and were actually disposed of. The big one is a Minnesota v. 3M here, which ultimately settled for $850 million. I believe it was filed in, I want to say 2011 timeframe and settled in around 2018. Originally, the state of Minnesota was seeking $5 billion in damages for disposal, for 3M's disposal of waste and discharging wastewater contaminated with PFAS near the Twin Cities for over 50 years. They alleged violations of the Minnesota Environmental Response and Liability Act, that's their version of CERCLA, and the Minnesota Water Pollution Control Act. In addition to that, they brought claims for trespass, for nuisance, and negligence. That, though, at the time was an eye-popping number, $850 million. And I think it really started to put the chemical industry on notice, right? Like, oh, we may be on the hook for quite a bit here. The second case I have here is North Carolina. It's not as big of a penalty, right? Even with the investigation costs and the penalty you have there, it's just $13 million, right? But what else do they have in there? They also required them to hook up people with contaminated wells to drill a new well or hook them up to municipal water, reducing their air emissions. And what I find so interesting, and this is a pattern we keep seeing out of litigation, is, and actually you need to investigate the health impacts from your contamination and figure out what the issue is there. And that's something that Rob Bilott, who was mentioned earlier, kind of pioneered. And I'll talk about that case right after this slide here. But first I want to talk about the South Carolina multi-district litigation. Those two cases that I just mentioned here, more likely than not, had they been filed later, would have been consolidated into the South Carolina multi-district litigation. When this case was first consolidated, I believe in 2018, 2019, it was about 500 cases. There are now 5,000 cases in this multi-district litigation, and these are predominantly related to the liability for the use of AFFF, or aqueous film forming foam, that firefighting foam that contains PFAS. And the reason they consolidate these is given, like it's often a product's liability claim for AFFF, that a lot of the factual and legal issues are the same, right? And they can decide those in a single bellwether case, or actually in this instance, 3 bellwether cases, that they would then apply the conclusions to the rest of the cases. So as I mentioned, here there's actually 3 bellwether cases. The first was scheduled to start just in June, this past June. That was actions by state attorneys general against PFAS manufacturers. Right before that case was set to begin, there was a proposed settlement for a couple of the the defendants in those cases. Literally the day before, I believe, is when this came out, and you can see the totals there. At first, when that was first announced, 22 attorneys general objected to that proposed settlement, but after some back and forth, apparently they've withdrawn that objection, and the judge in that case has given a preliminary approval for that settlement, and there's a hearing scheduled in February of 2024 for final approval. The next bellwether case that they'll decide is, what do I have here? That is water utilities who are suing some of these AFFF manufacturers. And that includes some of the water utilities right here in Wisconsin, right, who have filed suit against some of these manufacturers, only to get consolidated in the South Carolina multi-district litigation. I think the judge just announced that last month, that's what they would be proceeding to next, and they've identified 4 cases from which they'll choose the bellwether. And then finally, the last bellwether case is set to be is private litigants for personal injury claims against those same manufacturers. So this will drag on for a while, but it is a way to consolidate a bunch of these cases, because 5,000 is a lot for the federal judiciary, certainly, to handle all at once. And so it certainly makes it more efficient. Okay. This Leach, VEI, DuPont Day, whatever that is. This is the case, though, that Beth was talking about this morning. This is the subject of that movie Dark Waters that she talked about, right? And really had to do with widespread contamination in the Ohio River Valley, really near DuPont's Washington Works plant there in Parkersburg, West Virginia. Contaminate all sorts of private and public water supplies. But what is interesting here, you see this 2005 settlement. As part of that settlement, Rob Bilott got DuPont to agree to pay for that C8 science panel that established the link between exposure to the chemicals at their company and 6 human diseases, which spawned all sorts of subsequent study. And that was really a big jolt and to move the science along quite a bit. Also cool about that case is even though they ended up settling for that, it didn't actually preclude class members there from bringing subsequent litigation. So not only did DuPont have to study the health impacts, it also had to engage in medical monitoring. And then the class members of this case were able to use those results to bring suit against DuPont later on. And I think they had 2 or 3 bellwether cases there as well, not in this exact litigation, but in 2 separate sub cases there. But after DuPont lost on those 2, they ended up settling that case, and I believe it was for $650 million. $670 million, excuse me. I don't want to forget that 20 million. So this Hardwick case, though, this is Rob Bilott's next case that he filed in Ohio. At first, he was seeking to certify a class basically comprising of every American. Because you saw that number earlier, 98% of Americans have, a detectable amount of PFAS in their blood. And the idea is you've used us as a giant science experiment, right? And we should all be able to be in that class. The district court declined to certify the class that big, but did certify it for every Ohioan with at least 0.05 parts per trillion in their blood. That and as indicated here, that decision is currently being appealed. The decision to certify that very large class there. So that's an interesting case to follow. Guess what Rob Bilott's seeking as an outcome of that case? Another science panel. It's to keep studying these things because really information and knowledge is power. I put RCRA citizen suits on here because I just think these are really interesting. This is the Resource Conservation and Recovery Act. It does have a provision in there allowing for any person that's to be sued. That's the corporate definition of person again, to be sued for the disposal of solid or hazardous waste that creates an imminent or substantial endangerment to the health and environment. I've seen 2 cases at least filed under this, one in the Northern District of Alabama, where I think they got some injunctive relief to engage in some investigation. And another one was a case by the state of New Mexico against the United States Air Force for some contamination stemming there. That second case, since it was the Air Force and they were talking about AFFF, it got consolidated into the sort of South Carolina multi-district litigation. So one interesting thing about this is that you can actually sue state officials under this federal law, under a certain doctrine here. Again, that interesting fact that you can get injunctive relief to simply investigate the contamination first, and then maybe continue your lawsuit to determine, okay, what's the liability for that, or to clean it up. And then this is an interesting development here, especially when you're talking about suing the manufacturers of products that were supplied to our like Department of Defense and different military branches there, like AFFF. That was something that was designed for the Air Force. And there was this idea that there may be a government contractor defense. No, the government asked us to do this. This is why we produced it. That was actually an issue raised in the South Carolina multi-district litigation, and the judge said, no, there is no, here in this case, no applicable government contractor defense, that the AFFF they made wasn't, what did he say, sufficiently specific design or something there. So I thought, I just wanted to raise those because I think they're super interesting and maybe a type of case that's not brought as much but has been brought. And finally, I honestly, I put this on here because Dean asked me to. But this kind of ties back to what I was talking about before. Why did we get CERCLA and the spills law, at least in part, was because of the inability of actions like a private tort for negligence to actually get the desired results, especially when you consider the imbalance of power that so often comes with litigants, right? And so, but here is the prima facie case for a negligent tort here in Wisconsin. We're talking about a duty, breach, causation, and damages here, which is the typical prima facie case that you'll get taught at law school if you ever decide to subject yourself to that. Students, if you're still here, where'd you go? Anyway, but Wisconsin, interestingly, has this thing called an X factor. On top of that allows judges to decide as a matter of public policy to, even if the other four prongs are met, to not impose liability anyway. So anyway, it's just interesting. We don't really have any good examples, though, of this being brought here. And I think at least in part that's because we have the spills law. But one thing I wanted to point out, one piece of case law that we do have related to the spills law and like a negligence tort here, there is a concept in tort law called negligence per se, which is if you're found to have violated a safety statute, that means you're automatically considered to be negligent and liable for any injuries that result from that. And there was a case on that specifically here in the Wisconsin Supreme Court found that the spills law is not a safety statute for terms of determining negligence, right? And cannot give rise to negligence per se. So super interesting. All right. The PFAS-free drinking water guide, that is a guide that Midwest Environmental Advocates put together. I printed 10 of them off and put them over there on that table, again, at Dean's behest. But that's there for you. But if not, it's also available on our website, midwestadvocates.org. I think I also have our monthly newsletter and maybe some stickers over there too, if you're into that sort of thing. In addition, if you just have maybe a legal question or maybe you're seeking legal counsel or something like that, MEA operates an intake hotline where we listen to the public, right? And try to, even if we can't represent them, right? I can't bring every case and litigate it all the way to the Supreme Court, but can at least get them pointed in the right direction, maybe refer them to lawyers who can help them, things like that. So certainly encourage folks to call. There's also a form on our website. I really like Citizens for Safe Water Around Badger. That's CSWAB is what we call it, .org. Their website has a large PFAS library with basically every study you could ask for on it. And if you go to cswab.org, you will find that there. It's literally on their main menu. It says PFAS library. So it's a great source of information. Jack showed you the interactive PFAS data viewer earlier. I also want to mention DNR's Bureau for Remediation and Redevelopment Tracking System database, also called BERTS. This isn't as easy to use as the interactive PFAS data viewer, but it has much more data. And it can be filtered for PFAS. So you could actually see the list of all the contaminated sites in Wisconsin right now, as well as click on the documents there under. If there's been an RP letter sent or a plan for remediation, you can open those up and take a look at them. It's very dense, but it is there. And then finally on the attorney thing, I just like throwing this on there that the State Bar does operate an attorney referral service that you can Google there, but it's at wisbar.org, I believe. So that's it. That's what I had to you on different things today. Obviously, couldn't capture everything, but I hope that was helpful. Here's my contact information if you want to reach out, and I will answer any questions.